Hello, everyone, and welcome to One Civil Law. I hope you are having a great day as always, and we are here with more on the Georgia Ahmaud Arbery shooting. Since my brethren in the legal community, Legal Eagle and Nate Brody, have both released videos on this subject today, I figure why not? I'll release another video on this subject so I can discuss my current thoughts and analysis on this and see and show how my thoughts have changed. And I noted that Legal Eagle made the same misreading of the statute that I did in his video. He misread the same way I did, which I'm not sure if that makes me feel better or not, but someone else misread the same way, but that someone else was Legal Eagle, so I don't know. But anyways, let's go over the statutes that are going to apply. I've got a whole bunch of Georgia statutes to discuss. We're going to discuss the statutes and what they do and do not say. So let's get started with this. We are going to start with the first place to start with is the issue of the citizen's arrest, which has been very popular on this topic, whether or not the individuals in the truck and the person who are following them may have been engaging in a citizen's arrest, and whether or not that might give them some cover as a result of that. So we're going to go over this statute and with some revised eyes and provide some new commentary and read it, as Legal Eagle might say, like a lawyer. All right, great. So here's what we've got. Citizen's arrest. Were these people performing a citizen's arrest? Now, there is also an issue that is not clear here on the statute, that you might have to be intending to perform a citizen's arrest. The statute doesn't actually say that, but you actually, and I've tried to go a little bit into the case law, and I don't know that's ever come up. I looked at the case law and I looked at the annotations. I can't find a situation where it ever came up where someone said I didn't know that I was able to perform a citizen's arrest, but as it turns out, after the fact, I was performing a citizen's arrest. It seems like that you have to have the intent to perform the citizen's arrest. So that might right away be a bar on a citizen's arrest claim in terms of a defense of the people in the truck. That they might not be able to claim it because they were maybe not intending to perform a citizen's arrest. It's my understanding that in their initial interviews with the police, they didn't say they were intending to perform a citizen's arrest. It's my understanding that their lawyer didn't immediately say they were intending to perform a citizen's arrest. It's my understanding that the citizen's arrest idea first came about as a result of the prosecutor who decided not to press the charges, not as a result of the defense's person. So if they were not intending to perform a citizen's arrest, they might be done just initially right off the bat. But let's assume they were intending to perform a citizen's arrest. Let's assume that was their goal and that was in their mind, and we'll just go from there. But just as a note, you might have to have the intent to do so rather than the act. But let's assume that their subjective intent was they were trying to perform a citizen's arrest. That was their goal in life. Great. All right. So with that assumption in place, now let's read the statute with that in place. All right. A private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. And as I said before, this would be either you see it or hear a live report from someone who is seeing it. So the classic example would be the shopkeeper. The shopkeeper who pokes his head out the door and says, "Stop that man, he ran from me." That would be the kind of thing we're talking about. You didn't see it, but you're hearing a immediate, contemporaneous report from someone who did see it immediately. So that would be the kind of thing we're talking about. You saw it happen, or you're hearing a live report from someone who saw it happen. So you can rely on that. Okay. Then this is where I misread the statute before, because I misread the immediate knowledge requirement into the second sentence, and I shouldn't have done that. Robert Barnes called me out very politely, might I add, and I've looked at it and he's right. You shouldn't read it in the second sentence, and I was wrong to do so. So I'm big enough to admit when I made a mistake. I made a mistake. So let's read the second sentence with the revised understanding in mind. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. All right. So we have a general clause for any offense, and we also have a second clause which applies to felonies. Now, presumably, if it's a felony, you could also arrest within the scope of the first sentence. Because I don't think it's the case that the first sentence applies to all non-felonies. So presumably, if a felony is committed in your immediate presence, then the first sentence would also apply. So I don't think that, because you could read this statute in such a way, because if this offense is a felony, you could be reading, the first sentence wasn't speaking to that. So I don't think that's the best reading. I do think the first sentence is speaking to either one because it wouldn't make sense otherwise. So if a felony is being committed in your immediate presence or immediate knowledge, I think you're probably okay. But maybe not. But that's another issue. But there's another clause too. So we give you another grounds in addition to the first grounds. Here's your separate grounds. So grounds number 1, you saw it happen or someone reported to you, felony or not, presumably. Grounds number 2, also in the case of a felony exclusively, and this is where it's going to become critical, and the offender is escaping or attempting to escape, which by the way is immediately what's going to cause this to not work, that clause, a private person may arrest him upon reasonable and probable grounds of suspicion. So we see three things in this second sentence. We see 3 things that need to exist. It's a felony, the offender is attempting to escape or is escaping, and reasonable and probable grounds. We got 3 different things there that apply. So it is a felony, the person is escaping or attempting to escape, and reasonable grounds of suspicion. All right? So we need all 3 of those things in order to invoke those sentences. We have 3 different things that apply. And here's what's going to kill that analysis. Here's what's going to kill the second sentence and make it not work. Arbery was not escaping. How do I know that? I'm so glad you asked. Georgia Code defines what escaping is. So we can read that. Here's what it means to escape. A person commits the offense of escape when he or she, 1, having been convicted of a felony or misdemeanor. No, that's not applicable. Arbery hadn't been convicted of anything with respect to this. So we're just done there, right? We don't have to keep reading. He hasn't been convicted. 2, being in lawful custody or lawful confinement prior to conviction intentionally escapes. No. If the idea that he was escaping from the venue where this occurred, he wasn't escaping. He wasn't in custody. So no, he wasn't escaping. So again, you'd have to be the thing that's giving you the thing that's giving you the right of citizen's arrest. Again, I want to make this clear. You have to have all 3 things to engage in the citizen's arrest. It has to be a felony, you have to be escaping or attempting to escape, and you have to have probable cause. If you don't have all those 3 things, you can't engage in the citizen's arrest. So you might say to me, well, Blackleaf, he was trying to escape when they were trying to detain him. At that point, he was trying to escape. But they can't engage in the citizen's arrest unless he was already escaping before that. That's the key. You can't use like his attempt to flee from the incident as a justification for the citizen's arrest, because you had to have citizen's arrest in the first instance. They had to be engaging in the citizen's arrest or else they're going to be violating the law. We'll get to that in a second. So the only thing that could be the escape would be him fleeing from the crime scene, not the interaction on the scene. Because at that point, they either have the right of citizen's arrest or don't. And if they don't, they're done. So he wasn't escaping because he wasn't in custody prior to the interaction. The interaction presumably would be the attempt of custody. But again, he can't be getting in custody unless you have a citizen's arrest, right? You can't be escaping from a custody unless the custody is lawful, and it can't be lawful custody unless they were engaging in citizen's arrest, and it can't be citizen's arrest unless he was escaping. And he wasn't escaping because he wasn't in custody prior to that point. So he wasn't in lawful custody prior to the interaction. So they can't have citizen's arrest prior to the interaction because he wasn't in custody prior to the interaction with respect to whatever we're concerned about at this point. So he wasn't in lawful custody or lawful confinement and intentionally escaping from the custody or confinement. He can't be. Doesn't apply. Having been adjudicated of a delinquent or unruly act or juvenile traffic offense, intentionally escapes from lawful custody. He wasn't in lawful custody prior to the interaction. He wasn't escaping from a jail. He wasn't escaping from a prior citizen's arrest. He wasn't escaping from custody. He isn't escaping. Being in lawful confinement, intentionally escapes. No. Intentionally fails to return to any facility operated by the Department of Corrections if he was released. No. Revocation of probation. A person being convicted of a felony is punished by this, blah, 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 so forth and so on. So he's not escaping. None of these clauses apply. none of these clauses apply. He's not escaping. So if we go back to the statute before, we're kind of the second sentence cannot apply, because Arbery was not escaping within the meaning of 1610-552. This is the definition of escaping, and he's not escaping. He's not committing the crime of escape. Because if you look at the way the second sentence is structured, you need both those things. The offense has to be a felony, and the offender has to be escaping or attempting to escape. So even assuming he was committing a felony, which, by the way, he wasn't, and we'll get to that in a second for the second reason that this fails, but even assuming he was attempting to commit a felony, which he wasn't, he was not escaping or attempting to escape. He might have been fleeing, and that's going to come up a little bit later, but we'll discuss that. But fleeing is not the same thing as escaping. Escaping has an actual definition, and he wasn't in lawful custody prior to the incident. So it can't be a valid citizen's arrest under the second statute because he wasn't escaping to give the justification for the citizen's arrest. It could only be if the first sentence applies. It can't be because the second sentence applies. So all the people who have been putting their hope on the second sentence, no. It's just no, because he can't be escaping or attempting to escape, because then when we go, well, what is the definition of escape? Oh, here's the statute. What is the definition of escape? 1610-52, escape. Oh, that's good. Now I can go to read that and see what escape means. And none of these things apply to Arbery. Can't be. So therefore, it can't be the second sentence, because it can't be escape, because it's not escape within the meaning of the statute. So, no, it's not escape. So the second sentence is a non-starter for all the people looking for this to be a citizen's arrest. The only thing would be if the first sentence applies. So we're back to it has to be in their immediate knowledge or immediate presence. Unless, of course, you want to say the first sentence doesn't apply to felonies and only the second sentence applies to felonies. So if you want to go with that reading, only the second sentence applies to felonies, then you're definitely done. But I think that's the wrong reading, because it wouldn't make any sense. If a felony is being performed in your presence, surely if a misdemeanor is giving you justification, surely a felony is giving you justification. So yes, I think if it was in your immediate knowledge or immediate presence, yes. But the second sentence doesn't work. Your probable cause thing gonna go completely to heck. And as to the question of the security guards, it's exactly the same rationale. It's exactly the same rationale. And, you'd have to have a basis for it. So I can't say how every Georgia statute's ever applied to security guards, but at least on the reading, may an arrest offense if the offense is committed in his presence or with immediate knowledge. I suppose you could read that as non-time limited. Because I don't know that there's a time limit on that. So you can arrest for any offense that was committed in your knowledge or in your presence. So presumably there's no time limit on that. It doesn't have to, that the offense is committed in your presence or in your immediate knowledge. So presumably there's no time limit on that afterwards. So if it's committed in your presence, then you have an infinite time frame. If you have immediate knowledge of it, in other words, again, the shopkeeper. So it would have to be a contemporaneous report. So the shopkeeper tells you about it 2 hours later is not going to work. But the shopkeeper tells you about it as it's happening. Stop that man, and you happen to see him, and you don't complete the arrest, but you do it later, then presumably you can do that because you don't have a time limit. So presumably you could do it if it was in your presence at any time, or you had immediate knowledge of it at the time it occurred. So as it was occurring, someone told you about it. If you later learned about it from a videotape, then no. So I'd say even a videotape later, no, because it's not immediate knowledge. It's not your presence, and it's not immediate knowledge. It's knowledge you learned later about. So if it's something you learned only about from a videotape, then no. If it's something that you saw or had a contemporaneous report of as it was happening and then effectuated the arrest at some point later, then yeah, probably. Because there's no way the statute doesn't have a time limit on when you can effectuate the arrest, but it does set out conditions for the arrest. So that's what I would see. If I'm on the jury, he's escaping. Well, okay. I mean, if you're on the jury, okay. If you're on the jury, please enlighten me as to which of these provisions apply. What is escape? I mean, this is the definition of escape as a matter of law. You as a jury have the right to find facts. So please tell me the facts that apply to this statute. 1610-52, escape. A person commits the offense of escape when he or she does one of these things. Which one of these things applies and why? He was convicted of a felony? No, he wasn't convicted. He was in lawful custody prior to that point? He wasn't in lawful custody prior to that. He was adjudicated? He wasn't adjudicated. He was in lawful custody prior to the adjudication? He wasn't in lawful custody. He intentionally failed to return? He didn't intentionally fail to return. None of the facts apply to any of these things. How are you squeezing the facts into any of these things that define escape? The crime of escape is defined. It's right here in the title. In bold, actually, 161052, escape. This is what defines escape. How is Arbery doing any of these things? He isn't doing any of these things. So, yeah. Define custody? I mean, that's fairly easy. I mean, defining custody is fairly easy. I mean, the way you know you're in custody is if the answer is, am I free to leave? If the answer to that question is no, then you're in custody. That's how you know if you're in custody. If I'm free to leave, no, you're not. That's how you know if you're in custody. Incidentally, that'd be the same rule for Miranda. Custodial interrogation. You only have to give Miranda warnings if you're in custody, which is why the police often don't give Miranda if you're not, because they don't have to. But yeah, you're in custody if you're not free to leave. So also, if a reasonably prudent person wouldn't feel free to leave. So sometimes you see that in the case law where they technically are free to leave, but the police have put such a situation on where you don't feel free to leave. So it can happen. So you're in custody if you don't feel free to leave. But none of that applies because Arbery, there's no point prior to the interaction in which he wouldn't felt free to leave because there was no one interacting with him prior to the interaction. So there's no way he could be in custody prior to that moment. So no, he wasn't in custody. Who would he be in the custody of? If you're in custody, you're in the custody of somebody, right? If you're in custody, you're in the custody of somebody. The custody of the police, the custody of the security guard, the custody of whomever. You're in somebody's custody. Whose custody is he in? There's no one else there. He can't be in anyone's custody. So, that's the way that goes. The law defines escaping incorrectly. That doesn't even make sense intellectually. I don't even understand that intellectually. I mean, okay, let me rephrase that. Let me rephrase that. The law defines an escape. I guess it's possible the law can define things inappropriately. I mean, the law can always be incorrect, but we're looking to what the law says, right? And you're looking to what it says, and this is an escape under the definition. So if you're going to ignore the law, then you're a bad juror. You have to apply the facts. Arbery's not escaping. All the people out there who said, oh, well, you have probable cause. Well, they don't have probable cause of escape because he wasn't. They don't even have probable cause of escape. First of all, I think you could read it as that it factually has to be escape, but because the probable cause element's a little bit unclear as to what it applies to. But even if you said, oh, he's probable cause, no, they don't, because there's no basis to assume escape. Because who's he escaping from? There's no one to be escaping from prior to that moment. It could be the law being broken of escape is not the same as the word escape. I did look into the relevant case law, by the way. I did look into the Georgia Code annotated because that's free now thanks to that decision from publicresource.org. So I did download the Georgia Code annotated, by the way, and I read all the annotations to 17460, the citizens arrest statute, and there was no statutes on point that would apply that seemed to be on point. We could skim through them if you like. Apparently, there was something dealing with an arrest for murder 3 years after the commission of a murder. That could be exciting. Let's see if there's a time limit. Because I said, oh, there's presumably no time limit. Let's see if that's actually right. 1891. Let's see if you can arrest someone 3 years after a murder. Or if there's a time limit on this thing. That'll be interesting. Snelling versus State, 1891. Whether or not you can arrest someone for murder 3 years after the fact. Let's find out. I assume the answer is yes, but there's a Georgia Supreme Court case on point, so let's go read it. From 1891. I love this stuff so much sometimes. I really do. As I go into Westlaw and pull up a decision from 100 years ago. This is great. Snelling versus State. Let's see if I can read this and see if it tells me anything. Let's see. Special term. Oh, my Lord. I have to read 1891 language. Blah, blah, blah. That's a very short decision, actually. Okay. Supposing the facts to be thus, is there anything to resolve the defendant's guilt? We think not. A private person has a legal right to make an arrest if the offense is a felony and the offender is escaping or attempting escape. A private person may arrest him upon reasonable grounds of suspicion. Wow. The language apparently has been exactly the same since at least 1891. It's exactly the same sentence in 1891 today. So the language has not changed in the last 130 years. Okay, this is exactly the same language. Defense offense was a felony for which he was indicted, nor could he shield himself from the effect that they acted in ignorance, a purpose, blah, blah, blah. The purpose was distinctly announced. The evidence cannot be overcome. A need aid could receive it. The responsible girl, blah, 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 blah. Yes, okay. So apparently the answer to that question is yes. Yes, you can arrest someone for a murder 3 years after the fact. So there doesn't seem to be a time limit. So, good times. Do we need to know stinking Westlaw? I don't know. In order to interpret the statute properly, probably helpful. Yes. If we want to interpret the law properly, then yes, looking to what the law says, that's helpful. Looking to a decision from competent authority is helpful. I mean, if you guys just want to make the law up on your own, feel free to make up the law in your own head, I suppose. But this is the law. So, okay, it's not escape, and there's no decisions on point in terms of this that define it any differently. The laws I have just applying it normally. Difference for escaping felons and recapturing property, failure of officers, distinction between private persons and officers, citizen arrests, uniformed officer, charged harmless, burglary. All right. Good times. Carter versus State Supreme Court. 20. Okay, let's take a look at this from Matt. I'll pull that up on my own. Let's see. Carter versus State. Convicted of murder, following crimes, appeal, evidence, custodial statements improperly admitted. What am I looking for, Matt? What am I looking for? Yeah, we haven't gone that far in terms of the citizen's arrest and use of force. But yes, was that what I was looking for, just the use of force? But I don't think it's even a valid citizen's arrest, so we didn't even have to get into that. So, if that's all I was looking for, then yeah, I don't need that. All right, cool. All right, so let's go back to the issue of, was Arbery committing a felony? So assuming he was escaping, which he wasn't. Yeah, it's escaping or attempting to escape. Yeah, you would have. I mean, obviously, either way. I mean, escaping would be the completion. If you're escaping, you've completed the act. Attempting to escape is, you've taken a substantive act, so you're resisting the arrest or something. But yeah, we're not there. You can't be attempting to escape unless you're already in confinement. You can't be attempting to escape a confinement that doesn't exist. All right, so was Arbery committing a felony? Let's look into the relevant law and figure out whether that's true. Having figured out that he wasn't escaping, let's figure out, was he committing a felony? All right, so let's look at the relevant law. Some people have suggested burglary might be the one. So let's look at burglary. Was he committing burglary? All right. So first we have dwelling, meaning any building, structure, or portion thereof which is designed or intended for occupancy for residential use. And I don't know the case law on this point, and I think it's an interesting issue. of whether or not we're even there or not. Are we in a building structure or portion thereof which is designed or intended for occupancy for residential use? Good question. Unclear. It's in the process of being constructed. So I suppose at what point does a residential structure become a residential structure is a good question here. So there's a non-trivial question about, wait a second, is this a dwelling within the meaning of the statute? So there's that. Is it a dwelling when it's still under construction? I don't know. Let's assume the answer is yes, though. But there's an interesting question there about whether or not this is a dwelling or not, because it hasn't got its certificate of occupancy yet. So is it a building structure or portion thereof which is designed or intended for occupancy? I don't know. It's an interesting legal question, but let's assume the answer is yes. Let's assume it is a dwelling. All right, a person commits an offense or commits the offense of burglary in the first degree when, without authority and with the intent to commit a felony or theft therein, and that's when you can just stop reading, because we have no evidence to suggest that there was a felony or theft. Nothing was taken. The people said nothing was taken. And if he had a subjective intent to commit a felony, there's nothing on the record that would say it. The law allows you to infer intent from overt acts. So you can infer the intent from the overt act, but you need the overt act. So what is the overt act? And there isn't one. It's not a felony. It's not burglary to merely enter. You have to have the intent of the felony. What's the felony? All we see on the video is him looking around. He doesn't appear to touch anything. He doesn't appear to take anything. He's looking around. Maybe he's looking to see if other people are there. I don't know for what purpose. Maybe he's, skittish, but he's looking around. And does he have the subjective intent to commit a felony? Based on what evidence can we infer that? There isn't any that I can see on the tape. There isn't anything that says, he was stealing something or committing a felony. What felony? He isn't committing a felony. So burglary in the first degree is out. We can just stop reading because we didn't meet the element. And in a crime, you have to meet each and every element or you don't have a crime. So if you don't have each and every element, you're done. So we can just stop reading because we don't have each and every element. He didn't have the intent to commit a felony therein. So we're done. A person commits the offense of burglary in the second degree when, without authority, and intent to commit a felony or theft therein. And we can just stop reading. It's not burglary. Each and every element isn't satisfied. Hey, Nate, how are you doing? Good to have you here. I'm glad to have you here. Nate, if Nate is correcting me, let me know. Yeah, because... Oh, yes, it is a dwelling? Okay, cool. Awesome. Excellent. Nate says it's a dwelling. I believe Nate. Very good. It's a dwelling. Excellent. Very good. Thank you, Nate, for correcting me. I'm on board. No problem. I'm on board. That's fine. I believe you. It's great. No problem. Okay, it's a dwelling, so it's a dwelling, so we didn't have to get past that existential issue, but still, there's no evidence of an intent to commit a felony or theft therein. So it's not burglary. All right, great. What's next? How about criminal trespass? Okay, let's give that a go. A person commits the offense of criminal trespass when he or she intentionally damages any property of another without consent of that other person, and the damage thereto is $500 or less, and knowingly maliciously interferes with the possession of property. That'd be trespass against property, which, there isn't because there is no damage. There's no intent to damage, no damage. So that doesn't work. Person commits the offense of criminal trespass when he or she knowingly and without authority enters upon the land or premises of another person or into any part of a vehicle, railroad car, aircraft, watercraft, or another for an unlawful purpose. Again, what is the unlawful purpose? It has to be entering for an unlawful purpose. We want to distinguish here civil trespass from criminal trespass. Merely entering the land qualifies as a civil trespass. So if you want to sue Arbery for trespass, you could. Now, he didn't actually do anything while he's there, but sure, you can get your nominal damages. So if you want to sue Arbery for $1 and get an injunction, you can do that because it's a civil trespass. But is it a criminal trespass? No, because there is no unlawful purpose. What is the unlawful purpose? The unlawful purpose other than entering. It can't be the entering. So it has to have some other unlawful purpose. What is it? Again, from the objective evidence, from the videotape. We can assume a whole bunch of things in our own heads, but we have to have evidence because we're a court. So based on the evidence, what was his purpose? If you want to say, well, maybe he was casing the joint or something, it's like, do we have any evidence to support that? No. Not really. Not on the videotape, and we don't have any evidence to support that yet. So what unlawful purpose? It doesn't work. Enters upon the land or premises of another person or any part of a vehicle, railroad car, aircraft, or watercraft of another person after receiving, prior to the entry, notice from the owner that it is forbidden. Was it posted? Did he receive notice? We've seen nothing like that. We've seen nothing that said do not enter. We've seen nothing that there were like gates that he tried to close. We've seen nothing that he received prior notice. We've seen nothing like that would apply. So no, it's not, doesn't qualify because there's no notice. Remains upon the lands of another in a vehicle, railroad car, aircraft, watercraft, after receiving notice of the intent to depart. So if you remain after being told to leave, then yes, it's criminal trespass. Was he told to leave? No. He wasn't told to leave by anybody. No one was there. So that's not criminal trespass. And then there's something about permission to enter. And incidentally, in case you want to know, a person who commits the offense of criminal trespass shall be guilty of a misdemeanor. Misdemeanor would be the key word in your sentence here. So all that if it's a felony stuff doesn't apply. Because criminal trespass by itself is just a misdemeanor. It's not a felony. So merely trespass is just a misdemeanor. It's not even a felony. So all that second stuff goes bye-bye. First of all, he wasn't committing it. And even if it was a misdemeanor. And so the second sentence doesn't apply. So no, that doesn't work. So it's not trespass. It's not criminal trespass because none of that applies. All right, great. So now having determined that Arbery did nothing wrong, now having determined that Arbery did nothing wrong, let's look to what the people in the truck did, because they weren't conducting a valid citizen's arrest for the reasons that we've previously talked about. So what were the people in the truck doing because they weren't conducting a valid citizen's arrest? Let's figure out what they're doing. Let's start with kidnapping, false imprisonment, related offenses. Very exciting. All right, is it kidnapping or attempted kidnapping? So is it kidnapping or attempted kidnapping? Right? For attempt, we want to see that, first of all, the intent, which, as I mentioned, intent can be inferred from actions. Didn't I mention that a little bit earlier? Intent can be inferred from the acts. So we're going to do that exact same thing here. We're going to look to what the video shows and can we infer intent from the overt acts that were done. So do we have evidence of intent for kidnapping in order to make the attempted kidnapping? Let's find out. A person commits the offense of kidnapping when such a person abducts or steals away another person without lawful authority or warrant and holds such a person against his or her will. Sounds plausible. For the offense of kidnapping to occur, slight movement shall be sufficient. However, that any such movement of another person which occurs in the commission of any other offense shall not constitute the offense of kidnapping if such movement was merely incidental. So the way I read that basically is if you move a person from one person to another, from one place to another, it's kidnapping. You have to move them, but you don't have to move them any particular amount of distance. Even a slight movement will do. If it's a slight movement shall be sufficient. That's what it says, right? Slight movement shall be sufficient. So again, we're looking to attempt. Was it an attempt to abduct or steal away the person? Were they attempting to abduct or steal away the person in such a way that would have, had it come to completion, involved movement of even the slightest degree? I say yes. And I say that based on the video and what they were doing. Their truck is parked in the middle of the road. They're in the middle of the road with guns. So incidentally, it's armed kidnapping because there's guns. And incidentally, whether they're brandished or not is irrelevant. So even if you want to say, though, they were lawfully open carrying, it doesn't matter. As Nate the prosecutor will inform you, merely having the gun on you on you qualifies as armed. If you have the gun in your pocket and you go into the bank and say, give me the money, that's armed kidnapping, even if they never see the gun. So even assuming they were lawfully open carrying, it doesn't matter. It's armed kidnapping because they had a gun on them at the time. That makes it armed. Dude, it's not kidnapping? I don't know. Let's read the statute again and see if it's kidnapping or not. Let's read the statute and see if it's kidnapping or not. Right? We can read the statutes together. Let's find out. A person commits the offense of kidnapping when such a person abducts or steals away another person without lawful authority or warrant, and we've already determined they didn't have lawful authority or warrant because we already had that part of the analysis, and holds such a person against his or her will. For the offense of kidnapping to occur, slight movement shall be sufficient. So do we have an attempted armed kidnapping? Was there an attempt based on, because again, we can infer intent from what we can see on the video. So was there an attempt? And again, for attempt, you're looking for an overt act. You're looking for an overt act along the way. That's when you get to attempt. You're looking for some overt act and furtherance of it, then you get to attempt. That's how you know when you're attempt. So, are we far enough along the line to make attempt? Were they attempting to abduct the person? Yes, that was their subjective intent from what we know from their own testimony. We just want to talk to you. Yeah, with guns. We can infer an intent to abduct. We can infer an intent to steal away. We can infer an attempt to perform a slight movement. There's enough evidence on the record to make all these elements. So, no, they were not. Well, that's really informative, man. You know, that's really informative. Yeah, armed robbery instead of armed kidnapping in case of the bank, in case I made the mistake. Apologize. I was trying to reason by analogy. If I said armed kidnapping in the case of the bank, I meant armed robbery. Sorry. But you know what I meant. Apply one for the other. Movement shall not be considered merely to be incidental if it conceals or isolates a victim, makes the commission of another substantially easier, which I think you're there, lessens the risk of detention, is for the purpose of avoiding apprehension. The offense of kidnapping shall be considered a separate offense. The person convicted shall be guilty of these crimes, 20 years, life, blah, 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 blah. So, do we have attempted armed kidnapping? Do we have a substantial step? Do we have a substantial step of an overt act, the actions of which we can infer the intent to do? Abduction or stealing away a person without lawful intent or without warrant and holding that person against their will. That involves the movement of any degree. I think we're there. I think we're there for attempted armed kidnapping. I think we're there. But it's okay. If you don't like armed kidnapping, we have option number 2. We have option number 2, false imprisonment. So let's go with option number 2. Is it false imprisonment? If you don't like kidnapping, let's go with false imprisonment. Again, attempted false imprisonment. Or maybe actual false imprisonment. We'll get into it. Whether or not false imprisonment was complete or not. Let's find out. Well, this reads pretty clearly on what happened, right? A person commits the offense of false imprisonment when, in violation of the personal liberty of another, he arrests, confines, or detains such a person without legal authority. That's pretty clear. I mean, if you don't like my kidnapping reading, okay, no problem. False imprisonment. We got that for days. A person commits the offense of false imprisonment when, in violation of the personal liberty of another, he arrests. Well, that was exactly what they were trying to do. Another way of putting arrest is when you seize a person. That's also an arrest. So it's an arrest, right? Because they were trying to perform a citizen's arrest, right? They were trying to perform a citizen's arrest, but they weren't able to. So it's a non-citizen's arrest. In other words, it's an unlawful arrest. Uh-oh. A person commits the offense of false imprisonment when, in violation of another, he arrests, confines, or detains such a person. A person convicted of the offense of false imprisonment shall be imprisoned for not less than 1, nor no more than 10 years. So if you don't like kidnapping, no problem. I got another felony for you. The felony of false arrest, of false imprisonment. That I got for days, no problem. So if you don't like kidnapping, no problem. I got an option for you. False imprisonment. We got that for days, no problem. I came prepared. All right, so let's talk about self-defense and who does and does not have the right of self-defense in this wonderful scenario that we are wonderfully cobbling together. So let's look at the self-defense statute and figure out what does or does not apply. Here's the self-defense statute. It's 16.3.21 in Georgia. No problem. All right, let's figure out if any of this applies. A person is justified in threatening or using force against another when and to the extent he or she reasonably believes that such a threat is of or force is necessary to defend himself or a third party against imminent use of unlawful force. Yeah, so you have to have an imminent use of unlawful force. That's your self-defense analysis 101. It's either ongoing or imminent, and it has to be a use of force. Self-defense applies to a use of force. If I'm punching you, that's a use of force. If I have a gun, that's a use of force. Okay, so there has to be a use of force, either imminent or otherwise. What's Arbery's use of force? Because we're looking for the first person to act. We're looking for the first person to act, right? And so what is their use of force? Well, his use of force was when they tried to take the gun away from him. But we'll get to that in a second. We'll get to that in a second. We'll get to that in a second. All right. However, except as provided in 16.3.23, a person is justified in using force when it's intended or likely to cause death of greater bodily harm. So when can you use lethal force is what that says. Only if. So when can you use lethal force? So we have the first section. Here's when you can use force. How about lethal force? Okay, you can use lethal force only if you reasonably believe that such force is necessary to prevent death or great bodily injury, otherwise known as grievous bodily harm, is the way that's otherwise phrased, to himself or to a third person, or to prevent the commission of a forcible felony. So even assuming Arbery committed a felony, it would be completed, and it wasn't forcible because he wasn't using force because there was no one there to use force against. So it wasn't a forcible felony, and he's not committing a forcible felony now. So none of that stuff. All right. A person is not justified in using force under the circumstances of subsection A if. So here's where you can't use force. Here's where you get really screwed, people in the truck. Here's where you get really screwed. Initially provokes the use of force against himself with the intent to use such force as an excuse to inflict bodily harm against the assailant. Oops. 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 People in the truck. You don't get a self-defense claim because you're the ones who started this rodeo. You're the ones who had the guns out, and we're starting a forcible felony. You were using force, the guns, which were clearly displayed. You were using force, the guns, to effectuate either a kidnapping or a false arrest. And you were the ones who initiated this rodeo. Oops. So people in the truck, you don't get self-defense. Sucks. Because you're the one who initiated this. You're the one who initially provoked the use of force. All right. Is attempting to committing, or fleeing after the commission or attempted commission of a felony. So there we see slightly different language from the citizen's arrest statute. So maybe Arbery didn't have the right to self-defense because here we talk about fleeing, but again, we'd have to find a felony. So if Arbery was committing a felony, maybe Arbery doesn't have a right of self-defense either if he was fleeing after the commission of a felony. So maybe he doesn't have a right of self-defense if he was committing a felony, but we don't have any evidence to support that. Because we looked at burglary and it doesn't apply, and we looked to trespassing, and that's not a felony anyway. So Arbery would only lose his self-defense if he was fleeing after committing a felony, which he wasn't because there wasn't a felony, and we don't have evidence to support it. When else do you lose your self-defense? If you were the aggressor, well, that applies, or engage in combat by agreement, unless you withdraw. No, not so much. We're not talking about a fight. Any rule or regulation is void of no effect. So yes. So Arbery gets self-defense and the people in the truck don't, because the people in the truck are the ones doing the first bad thing. They're the ones who are initiating this party. They're the ones who are trying to commit the forcible felony. The forcible felony in question being attempted armed kidnapping or attempted armed false imprisonment. Take your pick. Either one's a felony under Georgia law. Doesn't matter. Take your pick. They're the ones who are attempting false imprisonment or false kidnapping without force because they don't have citizen's arrest because he wasn't escaping within the meaning of statute. So yeah. So Arbery isn't the ones doing it. They're the ones committing the felony. And because the McMichaels are the ones committing the felony, they're the ones who were the initiators of force. They're the ones who are provoking the use of force. They're the aggressor. So this is all going completely to crap for them. They don't have, the people in the truck don't have a right of self-defense. Arbery has the right of self-defense because he was responding to self-defense. He had a self-defense threat. So where does Arbery get his self-defense right from? He gets it from Section A. Arbery has justified in use of a person such as Arbery is justified in threatening or using force against another when and to the extent he reasonably believes that such a force is necessary to defend himself against such imminent use of unlawful force. Does Arbery in that position have a reasonable belief that force is going to be used against him in an unlawful way? I think you're there. In subsection 2, does he have reason to believe that there's a risk of death or great bodily harm and the force is necessary to prevent this or to prevent the commission of a forcible felony? Well, Arbery's trying to prevent the commission of a forcible felony. Arbery's trying to prevent the commission of a forcible felony. The forcible felony is the attempted armed kidnapping, the attempted armed imprisonment. So yes, Arbery is attempting to prevent a attempted forcible felony, the forcible felony against him. So Arbery's covered under subsection A, and even assuming the people in the truck had a right of self-defense at some point, they lost it under B1 or B3. Take your pick. So their right of self-defense goes bye-bye, and Arbery's right of self-defense is well preserved. Which brings us finally to our final statute, what these people are guilty of on the truck, having you walked you down this path. What are they guilty of? Well, they're guilty of murder, specifically felony murder. Why? Here we go. A person commits the offense of murder when he unlawfully, a malice aforethought, either expressly or implied, causes the death of another human being. Well, that doesn't quite work. Probably not subsection A. But that's okay. We have subsection C. A person also commits the offense of murder when, in the commission of a felony, such as attempted armed kidnapping or attempted armed false imprisonment, a person also commits the offense of murder when, in the commission of a felony, he causes the death of another, irrespective of malice. Oops. Someone died during the commission of a felony, the attempted armed kidnapping, the attempted armed imprisonment. And therefore, you shall be punished by death or by imprisonment for life. So, yes, I agree with Nate's end conclusion that the McMichaels are guilty of felony murder. And presumably the person on the truck too. Because the person on the truck was there. How did he get there? Presumably he got there because someone told him to be there, which presumably makes him either a conspirator or an accessory. And so he's equally guilty. $10 from Willie Czar. Love the channel. Thumbs up, please. I would also appreciate your thumbs up, yes. So yes, this is all good. So I agree with Nate's analysis. I agree with Nate's analysis. I agree that these people are guilty of felony murder under the relevant section. Now, if I were the prosecutor, in the interest of trying to, try to make this, I'm always worried about overcharging, and I'm always worried about what a jury can go, because what I can show on the tape and what a jury might do, who knows? So I'd probably be thinking very hard about including a lesser degree of murder, or I'd be thinking very hard about maybe some sort of manslaughter charge. Prosecutorial discretion, man, right? I could charge felony murder. I could charge first degree murder, but I don't know if I'd do it. If I could get a plea for something else, I'd probably be looking at a plea right about now. If any of these people want a plea, but we'll see. But I don't think they have a valid self-defense. Now, again, I wish to state very clearly that I still don't think this is a hate crime. We don't have the evidence to support that as of yet. It's not clear that they did it because of race. It's not clear that they were going out to do it because he was a black guy. Now, maybe they were, but we don't have evidence yet to support that. And I don't like to deal on evidence, and we don't have the record to support that yet. So I don't know that it was a hate crime. So the feds charge probably won't come to anything because we don't have evidence to support it as a hate crime as of yet. But Georgia, no problem. I think we're there. So, yeah. If you're worried, then you're a rare prosecutor. I don't know. I think prosecutors worry about that kind of stuff all the time. I think the prosecutors worry about a juror potentially not convicting and potentially doing the wrong thing. The cameraman is guilty. The cameraman is guilty if he's there as a result of a conspiracy or as an accessory. So presumably it's one of those two things, because how does the cameraman get there? That's the thing. How does he get there to film it? If because it was his cell phone too, right? So he happened to have his cell phone out as he was driving down the seat and just happened to capture it. Probably not. Probably not. He's probably there because they said, "Why don't you come down?" It probably was called to be there. So I'd be thinking accessory or conspiracy. I don't know if you can get to conspiracy. It would depend exactly on what was said in terms of the agreement, and maybe accessory. So is he guilty of something? Maybe, maybe not. It's a little unclear, but they have enough to at least, they have probable cause. So whether or not his charge will last the distance, who can say? We're not quite there far enough along. His liability is a little bit more dubious because we have to get into exactly what was said and exactly we have an overt act, him driving there. So we at least have the second half of a conspiracy charge. We have the overt act, him driving there, but we need to see what the nature of the agreement was. And yeah, so it's a little unclear, and what he knew and what he didn't know. So his liability is a little bit more unclear, but enough for probable cause, enough to go forward. So yeah, the camera person has been charged with felony murder. I don't know as an accessory, or was he at least arrested for it? So yeah, I don't know that there's been a formal indictment yet, but that's what's going on. So that's what I think. I hope you enjoyed this video. On a personal note, I have lost my war with Google Ads. I don't know what I did, but apparently I did something wrong. Yeah, apparently I did something wrong. My account was suspended, and then I appealed it, and my appeal has been denied, and I'm told it's final. And so now I can't set up any new accounts because I have been deemed to be a violator of Google Ads policy. So, good. That's a thing that happened. I'm not exactly sure how I violated any of Google's rules. I read them fairly carefully, and Google refused to give me any further clarity. It took me forever to actually get a hold of someone. I finally got a hold of chat, and it's like, there's no information available. Here's a list of reasons it could be. We're not going to tell you what it is. This is final. You can't advertise with us. So my advertising dreams are over, unless I go through a third party. So I may have to go through a third party rather than me do it myself, which is annoying. I lost my war against Google Ads. Or maybe I'll be able to set up a Google account, another Google account, and try to do that. So that'll be my next step. Maybe I'll try to start a completely different Google account and see if I can circumvent the rules that way. But I'm thinking that Google probably thought of that too. So I'm not sure what I did to piss off the Google gods, but they're irritated with me for something. I'm sorry, Google. I don't know what it is, what I did. I'm sorry. I didn't know what I was doing. I'm really sorry. So I don't know. Yeah, this is me paying Google. Google's still paying me for AdSense revenue. But this is me being able to pay Google. Google does not want me to give them money. I'm not sure why. I'm not sure what I did to anger Google to prevent me from giving them money. Google won't tell me. Google's angry at me. I'm sorry, Google, for whatever it is I did. I really am. I don't know what it is I did, but I'm sorry. Yeah, I don't know. Yeah, I still get the super chats. I'm still part of the partner program. So yes, I'm still getting AdSense revenue. Yes, so I'm still getting super chats and I'm still getting revenue from the channel. I'm just not allowed to run ads. So I'm getting money from Google. I'm just not allowed to pay them. I don't understand these things either. This is where we are. Hey, Leonard, how you doing? It's good to have you here. Oh man, yeah, I fought Alphabet and fought Alphabet One. Yeah, I start wearing Indochino suits. If I thought wearing Indochino suits would happen, man, I do good things. Yeah, I triggered your Google. I'm so tempted right now. How you doing? If you like this stream, please like this stream. Give me a like. Give me a super chat. Your super chats and donations are always appreciated. It helps me grow and keep going and helps me fight the Google overlords, to whom I apologize and I'm sorry for whatever I did. If they want to write through, all I want is for them to run through the statutes like I ran through the statutes. What rules did I violate? We're not going to tell you. How do I get further information? This decision's final. Okay. I'm sorry, Google. I really am. I don't know what I did. What's the super chat? Well, theoretically, there's a $sign somewhere under your chat window. So somewhere under the window where you're typing these things in, presumably there's a little $sign. And if you click on that little $sign, you can then select an amount of money to give me, and with a comment, and it will give me the amount of money with that comment, such as Nuvi just did for $5. Thank you, Nuvi, for giving me $5. File a lawsuit. I wonder what cause of action. Breach of contract? Good luck with that. The rules are so open. I'm going to have a real tough time. Yeah. So I hope you enjoyed this video. I want to thank Nate for dropping by. Always happy to have Nate here. Big friend of the channel. I hope that you have freedom again soon, Nate, in New York. And I also on a personal note, and this is really more personal. I weighed myself, and my weight is very distressing to me because it is way too high. And my temptation to eat food is really an issue. And I want to eat food in ways that, yeah, I have a food problem. And it's really causing me distress. I know I'm spiraling about it and stuff, but it's causing me quite a bit of depression. Seriously. And it is a real problem. I tried to engage in an activity that of a social nature, and I was not able to engage in the activity because of my weight, and it made me very, very sad. Not of a romantic nature, just social. So before you guys get too dirty, no, it wasn't that. This was me being out and about and trying to do something, and I wasn't able to do it because I was too heavy, and it really, really bummed me out. So it really sucks. So I'm having a rough day. Yeah, I'm having a rough day because my ego has been really bruised. Yeah, really, really hard. Yeah. Anyways, I'm gonna peace out. Love you guys. Later, guys. Ciao.